A quiet move inside the White House could soon trigger the toughest visa restrictions in years. A major policy move is quietly taking shape that could change travel, renewals, and re-entry rules for many immigrants before the year is out. This late 2025 proposal is not just another announcement. It may reshape who can enter, who can return, and how stable lawful permanent residency actually feels. This is Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. Keep watching because what looks like a narrow visa suspension could have broad consequences for workers, families, and green card holders. What we're seeing now. Over the past weeks, senior White House officials have confirmed President Trump's team is reviewing an executive visa suspension to be issued before year-end. Initial reporting shows the plan targets specific non-immigrant categories and could add new travel and re-entry scrutiny for some lawful permanent residents. This mirrors earlier bans, but insiders suggest the 2025 proposal would go further. With country-specific measures and expanded security screening tied to visa renewals and consular re-entry procedures. USCIS and DHS haven't published a policy memo yet. But federal agencies are already preparing internal guidance and operational checklists to implement the order quickly once released. What the proposal do? At its core, this policy aims to limit short-term visa access, slow permanent residency processing, and increase review layers across the board. For many applicants, that translates into longer waits, more requests for evidence, and additional interviews. Green card status won't automatically disappear, but the experience of being a lawful permanent resident could change. Travelers who stay abroad, visit restricted regions, or have inconsistent documentary proof of U.S. ties may now face secondary inspections, added forms, or even temporary holds during re-entry. Non-immigrant visa holders H-1B, L, 1F, one could see a reduction in stamping appointments and stricter eligibility checks when renewing abroad. And consular processing timelines for immigrant visas may be paused for certain countries while security reviews are completed. Why it matters. Similar steps in 2018 to 2020 led to case backlogs that doubled processing times in some embassies. Imagine a consulate that used to schedule interviews in 3 months, now taking 9 to 12 months. That's not theoretical, it's what happened before. If you're an H-1B professional, this means project travel, client visits, and visa stamping could become risky. If you're a family-based applicant waiting at the NVC, it could mean months or even years added to an already long separation. If you're a green card holder, unpredictable travel could derail plans, delay work, and create hardship for children, elderly parents, or ongoing jobs. The hidden catch. What nobody expected. This proposal is designed to function administratively rather than legislatively. That's crucial because it means the administration can change how the system operates without new laws or public debate. By combining targeted country lists with procedural rule changes, the administration can reduce visa flows and tighten re-entry rules without Congress ever voting. If your home country is added to a restricted list, standard immigrant visa interviews could be paused indefinitely. Joint sponsors and petitioners may face new financial proofs. Family reunions will be delayed. This hidden catch converts administrative tweaks into de facto policy shifts. It's policy by design, not by statute, and harder to challenge in traditional legislative ways. Who gets hit first? The most affected groups will be clear fast. H-1B professionals who travel frequently for work risk of visa stamping delays. Family-based applicants waiting abroad consular interviews may be postponed. A green card holders who travel often or live partly abroad increased re-entry scrutiny. Employers may face higher compliance costs and fewer options to bring international talent. Community groups warn that smaller sponsors and low-income families could be pushed out of the process by added verification burdens. Real-life case. Consider Maria, an H-1B 1B software manager who travels monthly between Manila and California for projects. A sudden country-specific pause on visa renewals forces her to postpone a business trip, miss client deadlines, and delay a critical promotion. Her employer now must navigate a project gap and possible visa backlog. A ripple that hits both family finances and company operations. What would this mean for you if your job or family plan depends on cross-border travel? How would a sudden hold affect your mortgage, your children's schooling, or your job offer? Steps to protect your case. Don't panic. Act strategically. 1. Delay non-essential international travel until the order is published. 2. Carry stronger proof of U.S. ties when you travel: tax returns, recent pay stubs, lease documents, enrollment records, and affidavits where appropriate. 3. If you're awaiting consular processing, monitor your embassy and NVC accounts daily and keep all evidence ready to upload quickly. 4. Employers should audit visa-dependent roles and consult immigration counsel to prepare contingency staffing plans. 5. For families separated by consular delay, document communications, financial support, and relationship evidence proactively. Every hour of delay can mean higher risk. Be ready to respond, not react. What to expect in court. Historically, similar bans faced swift litigation. Challenges in federal courts produced injunctions, partial stays, and lengthy rulings. Expect lawsuits again, but litigation takes months, and enforcement windows can still cause real harm. Congress may debate limits on executive authority, but legislation requires time, negotiation, and political capital. Administrative changes, however, move quickly. They can be implemented quietly, and they often create real-world effects long before the public notices what changed. That's why this moment matters. While Congress argues, agencies adjust the rules underneath, and immigrants feel the impact first. The bigger picture. As 2026 approaches, the administration's priorities are becoming clearer. Protect domestic workers, tighten security screening, and slow down certain forms of legal immigration through internal policy shifts rather than new laws. Family-based pathways are already feeling the pressure. Processing is slower. Requests for evidence are increasing, and interviews are becoming more detailed than before. Short-term visas for travel, study, and work are also facing added friction as agencies prepare for possible executive actions. This isn't just background noise. It's a coordinated approach that turns administrative procedures into practical restrictions. And here's the hidden catch. Internal policy, not Congress, is now the main driver of immigration change. Small adjustments inside DHS, USCIS, and the State Department combine into bigger delays, tougher screening, and unpredictable timelines. So don't wait. Review your travel plans now. Organize essential documents before filing anything new. And if your case is time-sensitive, speak with a trusted immigration attorney early. Stay connected to official government updates, not rumors or speculation. Reliable information is the only way to stay ahead when the rules shift quietly behind the scenes. If you found this helpful, like, subscribe, and hit the bell so you don't miss the next update. Thanks for watching Immiscope. We're tracking every development and will guide you through what comes next.